Welcome to the Justia Legal Guides video channel. Today, we will talk about estate planning. During your life, you may build relationships that are important to you. You may also get things large and small that have value or meaning. Many people want to make sure that the things that matter most to them go to the people who matter most to them after they depart. An estate plan can help you do this. Estate planning is an important part of ensuring that your property is distributed according to your wishes after your death. It can also help you express your desires when you can't express them yourself in the moment. There are a few main tools people use to plan their estates. First, we'll talk about wills, then we'll cover trusts, and finally, we'll cover powers of attorney and advance directives. You've probably heard of wills before. Wills are the most common estate planning document. They are essentially written documents that set out who should get what when someone dies. They'll sometimes also specify who should take care of any minor children if they're left without a guardian, and how the person making the will would like their funeral and burial handled. Wills are important estate planning instruments because without one, a estate will be divided according to the laws of intestacy. The laws of intestacy are a set of default rules for distributing a person's property after their death. The problem with allowing the default rules to apply to your own estate is that you may have a different opinion about who should get what and how much. For example, say Eliza has two brothers, Phil and Pete. She also has an ex-husband, Theodore, but no children. Eliza and her brother Pete are really close, and even though she and her husband are divorced, Theodore is still one of her closest friends. Phil, on the other hand, is pretty well off on his own and hasn't talked to Eliza in years. According to the laws of intestacy, in Eliza's state, if she dies without a will, her estate will be split evenly between her two brothers because they're her closest surviving relatives. Theodore will be left out entirely because of the divorce. But you can see why Eliza may not want that. Instead, she can say in her will that her estate should be split between Pete and Theodore and leave Phil nothing. And it'll only take her an afternoon to do it. The downside of having only a will when you pass is that your estate will still need to go through probate, which can be a long and expensive process. An issue that may come up during probate is the validity of a will. We won't go into details here, but wills generally need to meet certain technical requirements. A will can be contested and potentially thrown out if it didn't check one of these boxes. In addition to a will, you might want to create a trust. You can create a trust in your will and have it take effect after you die, or you can do it separately and have it take effect right away. A trust holds property for the benefit of someone else. The trustee is the person responsible for managing the trust, while the beneficiaries are the people who benefit from the trust. Beneficiaries are often family members, but they can be other people or institutions too. If you have a four-legged family member, they can be the beneficiaries of a pet trust. Trusts can be helpful when beneficiaries aren't necessarily capable of managing the property themselves. Let's say that you have two young children. It might be a good idea to make them the beneficiaries of a trust that holds funds for school rather than handing them the money outright. This way, the trust property will be managed by an adult with the skills necessary to preserve its value and distribute its funds under the conditions that you specified. Trusts that take effect during your life can be especially useful because they minimize the need for probate. Anything in the trust is held by the trust rather than the person who created it, so it's not part of their estate. This means that trust beneficiaries can get access to the property faster. That's the basics of wills and trusts. The third estate planning instrument we'll cover is the power of attorney. This is a document that gives someone else the decision-making authority that you'd normally have for yourself. There are two main types of powers of attorney. You can have a financial power of attorney that gives another person the right to handle your finances. Or you can also have a healthcare power of attorney that gives someone the right to make medical decisions on your behalf. A power of attorney can be durable, meaning it'll stay in place even if you become incapacitated. Most powers of attorney used for estate planning are durable, since non-durable powers of attorney immediately end when someone loses capacity, and that wouldn't be much use for estate planning purposes. You can also make a springing power of attorney. Normally, a power of attorney would take effect the minute you sign it, but a springing power of attorney only kicks in when a condition you specify is met. A power of attorney might be found in an advance directive. An advance directive specifies a person's wishes for their medical care when they can't communicate those desires themselves later. Advance directives are useful when someone is severely injured, terminally ill, enters a coma or permanent vegetative state, or develops serious dementia, among other things. For instance, someone may not want to remain on a ventilator if they've been in a vegetative state for more than 6 months. This is something they could specify in an advance directive. An advance directive can include a healthcare power of attorney to give someone else the power to ensure those wishes are followed. This person may also need to make medical decisions on your behalf while using their best judgment about what you'd want in a certain scenario, since you probably wouldn't have anticipated every possible situation. So now you know a little bit about some of the most popular estate planning tools. Wills and trusts are documents that ensure that your property is distributed according to your wishes when you're gone, while powers of attorney and healthcare directives are there to protect you while you're living, but can't express your wishes yourself. Thanks for watching this overview of estate planning. If you'd like to learn more, check out the Justia Legal Guide on this topic. If you want to talk to a lawyer, you can use the Justia Lawyer Directory to find estate planning attorneys in your area. We wish you the best of luck in resolving any legal issues that you encounter. Remember to hit the like button and subscribe to our channel for more Justia Legal Guides and law practice videos. See you in the next video.